after a talk about technology, we find ourselves with some technology problems in India. Shrishti Singh was going to be presenting, but she can't at the moment because she's having internet issues in her home. But I would like to tell you a little bit about her. And to do that, first of all, I'm going to introduce one of our other wonderful university colleagues, and he'll just tell you a little bit about Shrishti and what she was going to be presenting, and we'll hope to play that presentation a little bit later. So it's now my pleasure to welcome Professor William Barbieri to introduce the final paper presentation. Not high batting average on speakers at the moment, but Professor Barbieri is the Director of Peace and Justice Studies and Professor of Ethics in the Catholic University of America School of Theology and Religious Study. Bill's dedicated his career to the study of ethics, religion, political theory, and moral theology. He's a member of the American Academy of Religion, and he's published extensively in the areas of human rights, comparative ethics, peace studies, and Catholic social studies, and in other areas as well. So I'm honored to invite Bill to introduce our third and final paper presenter in the hope that we will see her a little later. Thank you, Bill.
All right. Thank you very much, Sarah. It's an unusual position, obviously, to have the honor to introduce a speaker who's not yet present and whom we hope will be here, but that's my task for today. It's an honor to introduce, even in absentia, Shrishti Singh. She is a UN Peace Fellow who is engaged in doctoral research at in the Department of International Law at the United Nations University for Peace in Costa Rica. I run the Peace and Justice Studies program here, and that's one of the top destinations that I encourage my students to study at, the UN University of Peace in Costa Rica. Shrishti Singh's research focuses on labor standards in garment supply chains in India and Bangladesh. She has worked in the Middle East. She has part of her legal education from the University of Turin, so she's a true cosmopolitan. Before moving to her current position, she taught at a law school in India and practiced law before the Supreme Court of India, the highest appellate court of the land. Her talk for today is entitled Labor Rights Compliance in Global Supply Chains. Is Mandatory Human Rights Due Diligence the Way Forward? Now, since she's not here to introduce the project, I'll just say a little bit about it to whet your appetite. Part of her study will focus on an emergent type of legislation in countries around the world that goes beyond mere reporting requirements to create a positive duty for companies to exercise human rights due diligence in administering supply chains. The paper proposes to highlight the issues being currently faced in ensuring implementation of labor rights in supply chains, despite proliferation of both legal and quasi-legal initiatives, and also to provide a comparative analysis of developments pertaining to mandatory human rights due diligence and evaluate their contribution to upholding labor rights in global supply chains. So I hope that's whetted your appetite for her presentation, and I look forward to welcoming her soon. Thank you very much.
Thank you so much, Bill. Terrific. And I just wanted to note that if we can get Shrishti back, we'll show her presentation later. If we can't, we'll ask her to record it, and we will post that on the conference website and make sure that you all have a link to that, because she's a terrific young scholar, and we really like to be able to have her share her work with all of us attending. So again, thank you, Professor Barbieri. And now I'd like to welcome my colleague, Mary Graw Leary, who is our Senior Associate Dean for Academic Affairs, to the podium for the next panel.
Everybody, thank you very much. A couple of housekeeping matters. This is how I teach my class. A couple of housekeeping matters. Remember, the cards are at the end of your rows, or you have cards. If you have any questions, feel free to send them and we'll field them to our esteemed panel. And also for those at home, they have the email address to send it to Duncan at cua.edu. I am really super honored to be a moderator of this panel. Now, I know that's something moderators say but it's true this time. No, it's true. And I'm honored not only because this is such an important topic and such an important conference, but also as the students here know, I teach human trafficking here at the law school. And much of the work that these folks do is what I teach them in class. So they're having an impact and our students are seeing it. And I'm so grateful. And my students also get to see what it means to be a lawyer committed to social good. And that's wonderful to have them here in person so that, I hope that you all know you are an example for many, many law students, certainly in my class. I'm going to introduce our panel in order of them speaking. I'll do all the introductions together. Each panelist will have approximately 15 minutes to speak, and then we will field some questions. So our first speaker directly to my right is Duncan Jepson. Duncan is the founder and managing director of Liberty Shared, an NGO working to combat human trafficking with legal and technical solutions. He previously served as a regional head of legal and compliance in the financial sector in the Asia Pacific. He has 10 years of supply chain management in his background, and he is currently the director and vice chairman of the Fair Rubber Association and Center on Illicit Networks and Transnational Organized Crime. To his right is Martina Vandenberg, the founder and president of Human Trafficking Legal Center. For 2 decades, she has been representing victim survivors of human trafficking. And I like to say when I give some of her work for my students to read, she was doing this work before it was popular, right? Before we were talking about human trafficking, before it was a thing. So she's really a pioneer in this area. She's testified before Congress, before the Helsinki Commission, and her organization has trained over 3,200 pro bono attorneys in this space. And then to the far right is the Reverend David Schilling, the Senior Program Director for Human Rights and Resources at the Interfaith Center on Corporate Responsibility. He is the co-author of ICCR's Social Sustainability Resource Guide and a member of the Coalition to End Forced Labor in the Uyghur region. Each speaker is going to speak about not only some of the challenges, as our topic suggests, but the particular work they have done in supply chains and indirect sources. So I will turn the floor over to Mr. Jepson. Thank you.
Thank you very much, Mary, and thank you very much for inviting me. Okay, that will thank. You are the experienced one. So why is this important and more popular than it was? I think the first thing, just a bit of my background, is that I started working on supply chains in 93 in China, and there were very few people at the age of 23 in China looking at manufacturing. And I manufactured all sorts of things, from pie brackets to shirts, baseball caps. And eventually I was asked by a large tobacco company if I'd be interested in managing their supply chains coming through Taiwan. Now, those of you, and I see a few CVP faces, will know that cigarettes from Taiwan into China in the early 90s was definitely a gray channel. And I had a certain set of skills that was interesting to them. I had not done anything in gray channels, but I knew how to take goods out and bring goods in. And one of the things that I find when I'm now speaking to, in front of, say, manufacturers and other people talking about corporate social responsibility and human rights abuse and supply chain is, oh, it's all too complex to do. And what strikes me is that that's one of the reasons why people do it, is because if you come down to cost, quality, and quantity, complexity allows you to negotiate those things until you get the right balance in your supply arrangements, and then you want to lock them in. And so complexity is an advantage if you happen to be the most powerful player on the ground. The second thing, then my life moved and I became a corporate finance lawyer and was at DLA Piper and eventually went in-house. And then the supply that I ended up being responsible for was money. And my career coincided with 9/11 and the financial crash. And the thing I found is that what I'd been used to in manufacturing, where you could say, oh, I just don't know, it's 2 tiers down, is that Homeland Security and the Department of Justice didn't like that as an answer when it was counter-terrorist financing. You couldn't say, I'm really sorry, but I just don't know. And what I didn't get to do was call in an NGO and say, look, tell me about this terrorist financing thing. Just 2-hour workshop, you're at the UN, explain it to me. When I went to see the regulator, I went to the FIU in Hong Kong and I had 14 jurisdictions. That didn't somehow make a difference to them. And they would say, but as far as the US is concerned, they see this as a criminal issue. They take terrorist financing extremely seriously. And NGO or not, 2-hour workshop, that isn't going to be enough. Where is your corporate governance? Where are your internal controls? Where's your risk management? And you would say, we've done all of that. And they're okay, great. Put it on an email when you get back to the office and send it. And you would say, we can do that. Or you go back to the office and you would say, we haven't done any of that. We need to create it right now and send it to the Department of Justice because they want to see it. And as I transitioned to doing more work on trafficking and forced labor, and I would go see more companies, they would say, it's just too complex. And I'm thinking, that's weird, because we managed $120 billion across offshore jurisdictions, and maybe less said about those the better, in the US, Asia, and the Middle East. And at no point was that ever an excuse. And we invested in a lot of technology, World Check back in the day, didn't use TRSS, but we used TR a lot, all sorts of other technology because we were required to. It says so in the anti-money laundering rules. And as I went and did more corporate accountability work, I realized that there was no way that most corporations in manufacturing were ever going to transform themselves into something more actually irresponsible, where they would go back to their office and simply just press send on all of their policies, because simply they were not obligated to do so. The excuse of it being too complicated was just always going to be enough to get them through a conference or a workshop or a board meeting. And that seems to me to still be the truth. And to sort of set it up, I hope, for Martina, was that when you start to look at corporate accountability mechanisms, I was, as a regional head of legal and compliance, we were constantly under pain of criminal law, whether that was because some idiot was manipulating the market in Singapore, or these are all things you can look up. I was at ING, problems in Taiwan or Thailand or India or wherever it was that someone might go to prison. And that was always the thing that would focus the mind of the C-suite. Is anyone going to go to prison? Yep. And that would be enough. Someone is going to go to prison, and that might just be you. And that was a incredibly powerful point of focus. When I started gave that up and did more work on forced labor, I realized that wasn't available. Now, why is that important? Because when you look at the plight of workers, the essential issue is that there is a failure to move power from the corporation to the workers, or the workers' proxies, those operating in good faith, obviously. And without any mechanisms to move power or adjust power within a system, and that's why we must not think of supplies as arrangements as chains, because the chain is not a system, it's basically binary. You shake one end and the other end moves, and it's always going to be the person who holds, if you see it that way. So you must think of it as a system, and you think, well, how do we move power around the system? And then you look and you think, well, what is holding people accountable in the countries or jurisdictions that I was very familiar with? Malaysia, Cambodia, Thailand, Taiwan, China, Japan. These are all places that I worked in and ran businesses in and had lawyers in. And the answer is, when I looked at forced labor and trafficking, the answer was there's very few mechanisms. And where I did find mechanisms were in the US, and particularly in the city, which is one of the reasons I'm living here. And I think that's the crucial question. Is partly it becomes an argument of, oh, is it too much? Is it too expensive to put in these systems and to create, for corporations to be burdened with greater liability and responsibility? Most of these companies, and certainly the companies that I worked for in finance, are making large profits. They can afford to put in the systems. And even if they can't afford it today, a lot of the big ones in particular can issue bonds, they can go to the market and they can raise the money to buy infrastructure to put it in place. And that infrastructure creates a balance within their own industry, creates control where there isn't something, and it creates a method of moving power back to the workers. The accountability mechanisms that we as civil society can use, or that pro bono lawyers can use, are vitally important, because those are also mechanisms of adjusting the power dynamic within a system in favor of those people that are vulnerable and victimized. And as an example, I will just pick, because I can see Anna, I will pick petitions to CVP. Now, as an NGO, I don't have any power to whether there is going to be a WRO or not, but I have the power to submit a petition, and I can use that petition to create certain power dynamic and concern at the concern of their corporation. And what I expected is that when I put a petition out there, exactly as I'd been subject when, for instance, when I was a lawyer, there had been dawn raids. The police had simply turned up with a warrant, I mean, this is in various countries in Asia, and taken stuff, and they'd taken people. There is nothing similar to that. I mean, we used to train our receptionists to be able to misread warrants and say, oh, no, and we'd have this sort of game that we play. This is a stupid thing. But the point is that we had to do this because we knew we were on a hiding to nothing, and minutes could be helpful, and that's really all we had. There is nothing that puts pressure on manufacturing corporations in the same way. But what I found is the petition itself is very useful. Suddenly the corporation is thinking, well, hold on, what's this? What did we do? And that's when I was incredulous when we did the first petitions, made them public, and I would watch their legal counsel and their C-suite say, first of all, well, we haven't done anything you didn't even know. You didn't even have the systems to know, because you've already told us it's too complex. So on the one hand, you've admitted for the last X number of years, you don't know, but suddenly when it hits the fan, you know everything. And which is it? And I found that, when this was, to me, was pretty fundamental, is that what happens with accountability mechanisms is they are an opportunity to change the balance of power within the system. And they put on the spot those people who, in my opinion, coming from a core background, are lazy. I found when I'm watching and listening to legal counsel in corporations, they don't know the law. They think, well, I need an NGO to come and talk to me about human rights. But as I know that Martina's going to explore fully, but I would think 307 is on the books. You're the legal counsel of global business. Go get a US lawyer, pay for a US lawyer, which will cost you a lot, and then learn. It is not a case that it's too complex and you didn't understand human rights and you needed, the UNGP, which I'm not much a fan of personally. I think they're way too light. To read the UNGP one afternoon over a coffee and say, oh, I never knew that. I did M&A a lot of my life. We did due diligence. I didn't need the UNGP to tell me when I did due diligence over a corporation to go look and see whether anyone was being abused. It was kind of like, do I want to buy a business where there is this going on? And of course, we didn't really talk about it. And I would say that we cleared a lot of things up before we completed the transactions, but I never needed to be told, go look. It was obvious that I didn't want to buy a business or enter into a transaction with people that were doing that. And I think that's where these accountability mechanisms are super important, is that they change the balance of power, potentially in the favor of workers, but as they start to precipitate and as they start to yield consequence to the corporations, they most certainly change the balance of power. And that's what we want to see more of. And things being complicated is a reason to do more work. It's not a reason simply to shrug and say, well, I just couldn't see 2 tiers below. I need to call in an NGO who've got no training on forced labor, whatever, never worked in the corporation, know nothing about supply chains, but they will go on the ground and somehow magically train people who have never had any kind of even secondary or tertiary education, but they'll offer this training that we'll get through. And the point I will make about this on the ground training is that my grandfather ran plantations for rubber plantations in Malaysia. I'm absolutely damn certain that when we petitioned against people in palm oil, I would have put his name on the docket because I know what he was doing and he didn't know necessarily any better. And I don't think he was a malicious man, but and I know that he wasn't actually, but he was not trained. He was did a degree in horticulture, and then that was a job that the British needed. He worked for the British government and managed plantations. But when we've interviewed people who manage plantations, their practices have been handed down for them by the last person. And the last person was often a relative and the person before that. And what they see when they go onto plantations is that there is cash, that every worker is paid in cash or has cash because they're paid every fortnight or every month. And this is on the things that we've worked on: rubber, sugar, palm oil, things like fishing. And so what you find at the bottom of this is that there is a kind of tiny cash economy working in the ground where supervisors and assistant supervisors can create penalties, can pay wages late, get them to do overtime for nothing. And the question we should be asking is if I'm a worker and I'm doing overtime every week and I'm not getting paid, where is the cash? Because it's somewhere. It's either billed into the business and that cash is never leaving the business, in which case it's owed by the business, or it's making its way to the plantation and it's not making its way to the worker and it's just sitting and being misappropriated by the supervisors. And this is the thing where you've got to intersect how businesses are run and human rights abuses, because it is still about people, product, and profit. That's what manufacturing is always going to be about. And the problem with human rights abuses is that we don't address the power dynamic within these supply arrangements. So I'm going to finish there and hand over to Martina.
Okay, for the record, Duncan is impossible to follow. In the future, I'd like to be the first speaker. Duncan can go after me because it's not fair to go after somebody who can make anti-money laundering funny, right? It's just way too high a bar. So let me just start there. I
want to go first as well.
So let me first start by thanking Catholic University for inviting me to participate today. It's wonderful to see so many familiar faces in the audience. And I have so much to learn from all of you that I feel a bit odd being on this panel. But let me start where Duncan left off. Duncan left off with rebalancing the balance of power. And that is what accountability is all about. And I start with the Foreign Corrupt Practices Act. Because if you look at bribery and the history of bribery, bribery was ubiquitous in 1977 when the FCPA passed. It was ubiquitous. Not only was it ubiquitous, in Germany, it was tax deductible. So if you paid a bribe, you could actually put it on your tax return as a legitimate business expense in Germany and write it off. That is unfortunately about where we are, 1977. When it comes to forced labor, because forced labor is ubiquitous. My colleagues and I at the Human Trafficking Legal Center say that forced labor is a feature and not a bug in global supply chains. And so we've had 45 years of FCPA. We have had 45 years of the Bribery Convention under the OECD. We have had all of that time. And now what Duncan is talking about the C-suite going bananas and the CEO and the board going nuts when there's someone literally knocking at the door, that's what the FCPA looks like. That's what accountability looks like. And that's what we do not have in the forced labor space. And when I say we do not have it, I mean, last year, the last year for which we have data issued by the Department of State, which was 2020, there were literally 1,115 prosecutions for forced labor in the entire world. So we did the math. That's about one prosecution for every 18,000 or more trafficking survivors that the ILO estimates are held in forced labor. That's not really a very good batting average. That's looking at the global picture, but frankly, my friends, the United States is not better. In fact, only 15 of those prosecutions were brought by the United States by every US attorney's office and Main Justice. 15 forced labor cases in the entire country. Never a single case using extraterritorial jurisdiction. Never a single case involving corporations and global supply chains. We have had 20 years. The Foreign Corrupt Practices Act, 45 years, but the Trafficking Victims Protection Act has been on the books since 2000. So the data depress all of us, I'm afraid. And so in light of the failure to prosecute, and we all hope that that's changing, and I see some friendly faces in the room who indicate to me that it might change soon. In the absence of accountability brought by governments, what workers have done, and interestingly enough, this revolution has been has been led by domestic workers. What workers have done is bring cases in the US federal courts using all the same laws that federal prosecutors could use, but don't. Under 18 USC 1595, my children joke I became a lawyer just so I could cite statutes to them, but under 18 USC 1595, there is a civil private right of action that is embedded in Chapter 77 of Title 18, embedded right in the middle of all of those trafficking crimes, forced labor, involuntary servitude. In addition, in 2008, Congress, which does so many things wrong, did something absolutely brilliant. They added extraterritorial jurisdiction. So we have extraterritorial jurisdiction over any party, any defendant who is a US citizen, who is a green card holder, or who is present in the United States. And present in the United States is a tricky issue, but I want to talk about a couple of cases that address this issue. So could we prosecute forced labor in corporate supply chains if we wanted to? Absolutely. Are we doing it? No. And so in the absence of that, what pro bono attorneys assisting workers have done is we have brought civil cases in the federal courts. And what I lack in Duncan's humor, I have made up for in exhibits. So this is a report that you can get on our website. It's the 15-year anniversary of the private right of action, which passed in 2003. And we actually did, Rebecca Carey, one of the fellows in our office, just did a really excellent. You may. So one of our fellows did an update, and the 2020 data is also out. What I can tell you is that there are more than 500 cases that have been brought by workers themselves in the US courts. And let's just pause for a moment and think what a heavy lift that is. You are almost, in many of these cases, someone who doesn't speak English as their first language, someone in many cases who may be undocumented, someone who has no trust for the judicial system, but still many of these workers, including about 30% of the cases that are brought by domestic workers in the US federal courts, still they have managed to bring these cases. So among my exhibits, other than the report that David just took, among these cases, I just want to talk briefly about two. One is a Ninth Circuit case, Ratha versus Fitania Seafood Company. The case number, for those of you who want to look it up, is 18-55041. This is a Ninth Circuit decision, which just came down. It was a case brought by Aneshka Friesman at Cohen-Milstein on behalf of Cambodian workers, male and female, who alleged that they had been taken from Cambodia into Thailand, tricked into forced labor, creating shrimp production for the US market. There are two very interesting things about this case. Number one, none of these crimes occurred in the United States. None of them. This case is brought under extraterritorial jurisdiction provisions, 18 USC 1596. The court in the Ninth Circuit case doesn't reach that issue, but says very clearly, for purposes of this opinion, we are going to assume that 18 USC 1596 is valid because, as you might expect, it's under attack by corporate actors who don't want to be held accountable, who say all the right things about accountability, and then when push comes to shove in the courts, say something quite different with their lawyers speaking for them. The other thing that's very interesting about this case, other than the fact that extraterritorial jurisdiction has survived to live another day in another case, is that the case itself is extremely important. It was a summary judgment case, and the plaintiffs actually lost on summary judgment. The Ninth Circuit confirmed that loss, but we managed to have extraterritorial jurisdiction stay, and we don't think it's the last of this case. The second case I want to raise is a case that just came down from the DC Circuit, and the case is Matos Rodriguez versus the Pan American Health Organization. Those of you who are in Washington, DC have probably driven by the Pan American Health Organization. It's that strange building that looks like a beehive near the State Department. The Pan American Health Organization was sued by Cuban doctors who alleged that they were sent to Brazil by the Cuban government to be held in forced labor in Brazil working as physicians. The program itself was called More Doctors, and it was an agreement, a deal between Cuba and Brazil. But the allegation is that in order to avoid controls in Brazil, the entire scheme was run through the Pan American Health Organization. And it's not a small amount of money. It's more than $1 billion allegedly paid in order to have these doctors serve in a different jurisdiction than their own. This case was brought on the theory that the Pan American Health Organization was financially benefiting, right? This is a financially benefiting case. And the complexities of this case involve the immunity of international organizations, but not really touching on that. What the court found in the DC Circuit in this brilliant opinion is that this was commercial activity in the United States, and that the allegations that PAHO was financially benefiting from this transaction could stand. And so this case now goes to trial. The other piece of this decision that I just want to read to you because it is so important. It's footnote 5, if anybody is interested in the footnotes. And I'll just read a part of it. But the DC Circuit says, Section 1589B, which is the forced labor provision, criminalizes knowing benefit, financial or otherwise, from participation in a venture that has provided or obtained forced labor. 1589B protects against involuntary servitude. 1589B also protects commercial entities that decline to benefit from forced labor and may be harmed by competition from products or services garnering implicit subsidies from forced labor. So to take a page out of Duncan's book, the reality here is that prosecution and civil litigation against bad actors is actually something that protects good actors. It protects those who choose not to use forced labor in their supply chains, who would otherwise be incapable of competing in a global marketplace where some perpetrators don't have any labor costs, or they are so meaningless and minimal. So I want to leave plenty of time for David. So I will just finish with one piece. So Duncan and his colleagues have done heroic work on withhold release orders. Many of us have petitioned as NGOs and as civil society members for withhold release orders to block goods coming into the United States market that are made with forced labor. It is my view, as someone who has worked in this field for more than 25 years, I started in elementary school, it is my view, preschool. Yeah, it's my view that these withhold release orders and CBP's enforcement under Ana Hinojosa and others is the most important thing that has happened to stop forced labor and introduce risk into the equation. Just as Duncan says, it is the most important thing to happen. Since, to be conservative, the year 2000, which is the year of the passage of the Trafficking Victims Protection Act. But to be a little more bold, this may be even as important as the passage of the 13th Amendment to the Constitution, right? Because we have never seen this level of enforcement. And you may have already discussed the numbers, but the numbers are remarkable. In the fiscal year 2021, they detained approximately 1,469 shipments of goods worth $500 million. $500 million is a number that corporations will actually listen to. In the strategic litigation field, the work that we have been doing for 17 or more years to bring cases as strategic litigation, we have in both civil public judgments and public settlements, keeping in mind that many of the settlements we do are confidential and private and never publicly reported, we have actually had ordered, not collected necessarily, but had ordered about $255 million. And so in 1 year of CBP enforcement, it has outstripped what we have been able to do in strategic litigation. So I remain totally committed to strategic litigation, but I also am very bullish on withhold release orders and very bullish on Customs and Border Protection's enforcement of the Tariff Act. And here's why. because the United States soon will not be the only country with a Tariff Act import ban like system. Under the USMCA, or as the Canadians call it, CUSMA, because Canada comes first. Under the USMCA, Canada and Mexico are both required to have import bans. Canada is apparently considering a bill at the moment that goes even further than ours, and it wasn't just ban forced labor or child forced labor or prison labor. It would also ban all child hazardous labor. That's even further than the Americans have gone. In addition to that, Australia, the United Kingdom, the European Union, Japan, Taiwan, and multiple other countries are all considering import bans. And the global NGOs, frankly, are on the march on this as an advocacy campaign where so many disparate parties have been brought together. And so what we call that advocacy campaign is no safe harbor for forced labor, because there should be no safe harbor anywhere in the world for goods made with forced labor. Thank you.
Turn on the mic first. Boy, there's so many things going on in my head. One is the response to Duncan and to dear friend here. It's really like, I was fortunate enough to be sitting in the 6th row at Riverside Church when Martin Luther King gave his speech entitled Beyond Vietnam, which was really, profoundly meaningful as a kind of a first-year student at Union Seminary across the street, to be in that setting. And I remember the impact of, okay, if we don't address like all the issues surrounding Vietnam, and irrespective of whether Martin Luther King said, irrespective of whether the New York Times, most of the papers in the country were against him taking a stand on this when he was a civil rights leader. Now, this is like 3 years after he got the Nobel Peace Prize. But the reason I'm raising this isn't all of that as much as Rabbi Abraham Heschel got up right after King finished and said, all I can add is a sigh. And that's the way I feel. Because, when you look at the impact of the conference from this morning, and it's still mid-afternoon, so many issues have been brought up, but also in a context of not just despair. And Duncan, you describe what are the challenges, but also what can work. And you're saying essentially that any one of us, our institutions can get engaged and involved. And ICCR did join and submitted the 1307 on the part of 10 groups that were working really closely together around Uzbek cotton forced labor. So no question that, this is it's a movement. And our, the Interfaith Center on Corporate Responsibility, I'm thinking so much about history because we just had our 50th anniversary gala last Thursday night. And that unfortunately had to be virtual. But you think about the impact that, okay, a few investors get together. At first, it was not interfaith. It was really Protestant. The National Council of Churches and all the mainline denominations in 1971 filed a shareholder resolution, a 500-word statement that shareholders have the right to file with companies. They're reported to the Security and Exchange Commission. And that was the first resolution that was on a social human rights issue. And the reason it was filed wasn't so much the organization, it just got formed and its intelligence. It was a young minister from South Africa that contacted ICCR to utilize its role as shareholders in companies to get them to withdraw from South Africa until apartheid was abolished. And the young minister grew up to be Archbishop Desmond Tutu, who was with us the whole way. Unfortunately, died this December, but amazing person, filled with just this vigorous commitment to justice, not just in South Africa, but anywhere. And this impish desire to always dance. So when he was made the Archbishop and he was in Cape Town, often, after the sermon, he would go into the congregation and they dance. So I think there's
We have to dance after this.
yeah. So instead of talking anymore, let's dance. I think that would be really good. But I do want to say a few things about the whole question of the transparency in supply chains, the complexity, et cetera. There's no question that there wasn't any real plan to do all this outsourcing, but when it began, I started to work at ICCR in 1994, it was moving. And so our investors we were filing shareholder resolutions with apparel, especially, but also, footwear, automotive, agriculture, tech, calling on the companies to put in place policies related to human rights in global supply chains. And so I noticed that as we were filing those, yes, they were really focused on standards of the ILO. But when you looked at the reality, there were two things that really struck me. One was that essentially the codes were dealing only with the first tier, that primary relationship, that forget the subcontractors, subcontractors, and down to the material level. That was number one. But number two was, if you really looked at the codes that were being adopted by a lot of companies in the 90s, it was essentially strip away some of the fluff, but it was essentially you follow local law in the country where you're operating. And so there wasn't, we had to work really, really hard to get ILO core conventions into those codes that didn't have really any kind of a harbor that would actually be able to be implemented systemically within a company all the way through its supply chain. But to me, it was really brought home in terms of the subcontracting. This was like maybe a few ICCR members and I were in the New Delhi area, and we're visiting like 3 factories, a company that was sourcing there, and there were different sectors. One was an apparel company. And so we did a walkthrough of the factory, but usually you don't have a chance to really sit down with management to talk without the company there. This was kind of unique in that after everything, the walkthrough, et cetera, we had a chance to talk to the manager, and the manager essentially said, candidly, that we signed the contract for orders that are much more than we can produce, because we want to have that business going forward. I mean, it's totally understandable. But so after, it was so graphic, after that talk, we met with some NGO friends that were working in that area, one of which was a staff person for Saywa, which is an amazing organization of women, about 2 million women in India that is working in the informal sector. So for any company or organization, that is a really important, really important organization. But they knew right across the street, we walked down this alley and there was a building kind of falling apart, but they knew some of the workers there, and we gained access and actually went through that after looking at the factory that had good lighting. It had fire extinguishers, really. It had a range of, not so much, in terms of the aisles, where a lot of times there's material that really could be it could mean a fire hazard, blocking some of the areas. So at this place, no light. It was very, each room had some organization around some of the sewing machines, but it was just unbelievable. And then we ended up talking to some of the workers about, there's no formal contract, there's no pay slips, et cetera. And that was working for the same company, but it was just removed by one little block. And it just pointed to me that, we really need to work much, much more to get beyond that. And now some of the legislation, some of the WROs, some of the companies themselves recognizing they need to really engage and involve their suppliers to address that, plus their recruitment agencies. That's another piece of it. And, Kevin is the chair of our leadership group for responsible recruitment. We have a number of people here and been from Walmart that's been a part of that. That's companies working with Verite and ICCR, IOM, et cetera, to really go deeper. And that's where we need to concentrate. But if I want to say at least a little bit about investors, because I think that area is changing. For us, we've always been on, kind of the cutting edge because our starting point was human rights. And that was the issue. And the recognition that a lot of the churches, a lot of mainstream denominations would have, here's the building, here's the finance office, the pension for, pension investment programs. And here was the social justice office. And there wasn't any connection. So here you were working hard for peace, for economic justice, for gender justice, and then your investments in the case of the Vietnam War were putting in Honeywell, making napalm that is killing people. It just goes on and on. So that kind of bringing together, I think, was really important for us. Now within the investor community, I would say that there are tremendous opportunities, partly because, we are much more conscious that it's not companies alone that have responsibility to respect human rights. Investors have that same responsibility. So 3 years ago, we created the Investor Alliance for Human Rights that a number of mainstream investors are joining. You don't need to become a member of ICCR, so it's expanded. And now we're working with a lot of, public pension funds, more than we have before, big asset managers, et cetera. So we're getting, some of our statements around COVID, like $9 trillion from the investor community based on the 250 signatories. Or the Rana Plaza, which we worked on it's been 7 years now, where, basically $5 trillion of those that signed on to a pledge to work to support the accord, to get supply chain transparency, to get money for the victims of the 2,500 that were injured and over 1,300 workers killed, because there was subcontracting into Rana Plaza. And a number of the companies didn't know that they had stuff there. The workers did. So I think my final point is that in the case of Rana Plaza, workers left the structure, eight stories, because they saw cracks the day before April is 2013. They were literally forced to go back in. And they got, all the, assurances from the owner, from some of the officials that said everything is fine. So they were forced to go back in and obviously lost their lives and many injured. So this is not just about, like trying to find the most effective mechanisms, technology to figure out how to trace. We've got to engage workers they're already engaged, but there's this whole question, Duncan, about the power imbalance. We have been so concerned about that because forever as globalization emerged, you had the retailers, the companies, here, and then the suppliers here, and the workers. When did they come into the equation? We spend some time in an assessment to interview 25 workers who never really got reported back as to what the results were, even though it created some corrective actions. So to me, we as an organization, we have become totally committed to worker-driven social responsibility, where workers themselves organize, and then investors can make a difference in supporting those initiatives. So when going to, this was during COVID, going to Tyson, because of all the issues in the factories, the food factory, where workers were essentially essential. But some of those workers were saying, yes, we're essential, but where are the essential, wages? Where are the essential, the protections in the factory where they didn't have masks, et cetera. So those kinds of coming together of investors and those that are on the ground, I think to me makes a huge bit of difference as we're using, good technology, et cetera. But let's not forget the most important piece of the transparency. Workers absolutely know whether a bill of worker rights by a company is actually being implemented or not. If the line speed is still as severe as it is, you're going to have accidents, et cetera. So I really feel like this is a moment to really move forward. So coupled with if you have WROs coming from a number of companies, if you have investors more engaged, and even some of the mainstream investors are looking at ESG and recognizing that the S has been silent in their look. So we have to make sure that social sustainability is as important as the environmental, which is super important, and the governance, which really directs where we're moving, in terms systemically in the future. So I really feel so hopeful. I mean, first hearing all these great people this morning and coming together like this, bringing us together, Mary, is really, and Sarah, it's so important. But thank you.
Thank you. Thank you very much. So just a reminder, if any of you have any questions, we have actually about 25 minutes for questions. Write them on your cards and Professor Duggan will bring them up to us. But as my practice when I moderate a panel, well, first of all, you can see why I gave them the introduction I did. These are amazing people, but they also get handicapped. Poor Mr. Jepson goes first and then he never gets a chance to comment. So as we're collecting our questions, I just want to turn to the panel that if there's anything they wanted to comment upon what another panelist said or amplify with their own experience, feel free to chime in that now. If there's any, or was it all perfect? Go ahead, please.
So I think I'd like to add is that one of the things that is important to keep in mind is, what are we aiming for? Mm-hmm. So for me, for Liberty Shared and my work, and say for my students at Princeton and Georgetown that I teach, where I would like to be is moving from a linear economy to a circular economy. Mm-hmm. That is a massive ideal, but in a circular economy, this would not be an issue because there would be feedback to workers, there would be power sharing because it needed to be circular. And so if that then is the aim, then a lot of these discussions move from a moral imperative to a categorical one. And when you put in climate change and migration and conflicts, the need to move to a circular economy of sorts and be transformative in that way is important. And I don't have any children, but I know at least for my students, I want them to be able to live in a world that's actually livable. And so when we start to talk about the role of businesses and investors and others, in modern capitalism, there is so little feedback. It is so easy to make money and not worry that you will be held accountable for the way that you behave to workers, to the environment, that is fundamental to the way that the modern market economy works. So we need more accountability, and we need investors and others to understand that. And that really has to be our goal, and we should always keep that in mind. It's not necessarily that, oh, we want the next goal is more due diligence, or that it's those people who are already acting and profiting take a little more care. It fundamentally is about that there is feedback to them that their behavior is unacceptable on the basis that it will not lead us anywhere into changing the way that we use the planet and we use other people. And that to me is pretty fundamental to keep that in mind, because every other argument starts to diminish in front of that larger argument. And that's why I'm not a big believer in frameworks and so forth that are not mandatory and are not obligatory, because if you've ever been inside a business and something isn't mandatory, you will push it as far as it goes. And I can tell you, having been the head of legal where it was both criminal and mandatory, FCPA is a great example, because I had FCPA problems in Thailand and a couple of other places. And we always had a line, put $1 million in contingency funds, because you're going to have to hire a US lawyer, and that's what it will cost just to do the due diligence work. Not even the possibility that you might have to be dealing with the DOJ. And we employed a firm, I think it was Jenner and Block, and we had $1 million, and we had $1 million in that. And you know what? We passed that $1 million expense to the subsidiary, and they were like, why should we pay it? Because you screwed up. And now your bonus is gone for 10 years, because you're never going to pay that $1 million back from the group as head, and you shouldn't have got involved in it in the first place. And those loops are not embedded in most sectors other than, say, public health, finance, insurance, and so forth. And this is where we've got to get to, is that much bigger prize of a transformative movement to a more circular economy.
And I wonder, Mr. Jepson, if you could define circular economy for some of the audience.
So linear economy is where we're at, which essentially is summed up as take it, make it, and waste it. So basically the view is that we are going to take investors' money and we are going to create some sort of productive process, and then we will draw resources, human capital, material capital. We will create something that will give shareholder value maximization. So I come from an investment background and in finance, my degree. So that's where you're going to end up with. And what residual comes off, what sunk cost comes off, we're going to suck it up because we can afford to, because investors are being compensated. And if you remember, that's the line Jack Welch had most of the 20th century, until a few years before his death, when he suddenly realized post-financial crash, actually, we should be living in a broader stakeholder accountability. And you can see that from Larry Fink's letters from BlackRock. So in a circular economy, that waste is completely unacceptable. And of course, that may be an ideal, but we are getting to a point when, whether it's fishing, whether it's the apparel industry, whether it's fast fashion, so forth, whether it's extractives, plantation, so forth, where that waste is becoming unacceptable at a cultural level, certainly for millennials and Gen Z. But also, I think for those of us, I'm Gen X, and I guess for boomers, they're thinking, well, wait a second. For those of us who are thinking about future generations, we need to see that waste being radically reduced and pushed back into the economy so that it keeps feeding it. And that's the difference between, say, linear and circular.
Thank you. Martina, did either of you have anything you wanted to add before your questions?
So on the issue of the power dynamic, I think that's absolutely important. And it's right now, it's just built into a lot of the supply chain systems. So to do that, one of the reasons we've really spent some time with a new initiative that comes out of the American Bar Association's Human Rights Working Group. And that is, initially about 2 years ago, they did a kind of a guidance around forced labor, and then another one on child labor. But then they realized that that wasn't at the crux, and they thought, okay, as a law institution, what can we do to really build model clauses for contracts? So a whole lot of energy has gone in to that. It's kind of centered now at Rutgers at the law school, and Sarah Dudash, another great Sarah, is heading that along with Olivia Wyndham Stewart, who has a lot of supply chain work. But the key is that now there is a kind of a model for companies as well as suppliers, and language that needs to get integrated when you sit down to talk about price, quality, delivery. And there's nothing really there about the human rights criteria. So this is moving in that direction. And that's why we as the Interfaith Center on Corporate Responsibility will take that to a lot of companies and other investors, because it can be a mechanism to help balance that power and really impact the lives of workers.
Thank you. Thank you. Before I turn to some of the audience questions, and they're all really great questions, I have a public service announcement. It's been handed to us, those of us who aren't on our phones, that Ketanji Brown Jackson has been confirmed to the United States Supreme Court.
If Desmond Tutu were here now, he'd be dancing right here. So I think we should dance.
So one theme I think we've heard from our panel is this idea, using my words, of multiple pressure points, right? Strategic, litigation, being aware of where the money is, accountability, et cetera. We've got a numbers, and we've also heard wonderful things about the CBP, which is like the most popular agency, I guess, to work for. So, right. A couple of the questions have come up, one about the SEC and how for accounting rules, if a company doesn't do what they're supposed to, there's some jurisdiction there. I'd like to take that question. There's another one about the CBP. Where do you see the administrative regulation here as advancing some of the work that you're doing? If you see it at all, is that another pressure point that's been underutilized? Thoughts?
I can just start very briefly. We haven't focused on the SEC, and I think Duncan is better poised to answer that question. Although I will say that ICAR is pushing forward with what they call the FCPA for human rights. And so what they particularly love about the FCPA is the books and records piece, right? I actually did Foreign Corrupt Practices Act investigations at Jenner and Block. So, I have to say the reason that the accountability provisions in the FCPA work is because clients like Duncan hire investigators and lawyers to go out and do an immense internal investigation, figure out who paid the bribe, figure out who knew about the bribe, fire all of those people, do a white paper, give the Department of Justice all of the hot documents, and then throw the company before the Department of Justice on their knees begging for mercy. And so really, there is an FCPA global industrial complex for enforcement that does not exist on forced labor. So on the administrative question, though, because I think the administrative question is an important one. The law that I didn't mention that's come up multiple times, I think today, is what some people at CBP call UFLPA. So the Uyghur Forced Labor Prevention Act, UFLPA, kind of like Papa, it's a strange acronym, but the Uyghur Forced Labor Prevention Act, for those of you who are all really diehard administrative law geeks, like so many in this room, tomorrow there will be a public hearing from 9 a.m. to 1:30 p.m. with lots and lots of people intervening in 3-minute increments to talk about the enforcement of the Uyghur Forced Labor Prevention Act. And what's important about that law, again, from an administrative perspective, is that that law has a rebuttable presumption that there is forced labor. We are holding Xinjiang and Uyghur forced labor to the same standard that we are holding North Korea. And if you follow the detention orders under the CATSA, under the North Korean law, what you will see is that CBP has detained false eyelashes made by North Korean workers in China. And there have been detentions, and there the burden of proof, it's just a given. It's a rebuttable presumption. And then the company has to prove that it's not made with forced labor, or it's not, in this case, made with Uyghur forced labor. What I find disheartening as I read the 180 odd comments that have been put in through the notice and comment period that CBP recently held on the Uyghur Forced Labor Prevention Act, what I find disheartening is corporations, again, that say all the right CSR things, just don't believe them because what they say in their comments, they give themselves away, and their corporate lawyers who draft those comments for them give themselves away, because it is not just about making the Uyghur Forced Labor Prevention Act unenforceable. It is about dismantling Section 307 of the Tariff Act, right? And the fact that the corporations hate 307 so much is an indication to me that it's working.
Fair enough, fair enough. Did you have anything to add, Stephen? Oh, good.
Well, again, it's in the US context. And of course, we, as an investor or a coalition of investors, always looking for greater transparency. And as we kind of lined out, Kevin, you did it well this morning in terms of where we've gone, like the California Transparency Act, which we didn't feel moved the needle, except that some companies for the first time had to think about human trafficking. And then, of course, with the UK Modern Slavery Act, Australia, et cetera. I think there's a little bit more teeth in each. But even, I mean, to me, as we sat down with companies, it was really helpful that, you know, President Obama, remember him? He addressed the whole question of procurement. And it was an executive order, it wasn't a law, but it meant that, you know, all those that had any government contracts for products and services would have to go through a process, you know, to make sure that there isn't, you know, forced labor, human trafficking. And even that without being the teeth in terms of law. And many companies were, you know, doing things already, but I do feel like, you know, the progression needs to keep going until there is real serious. And I think we talk about the level playing field, but that's not just a concept. I think so many companies just worry that, you know, others that aren't doing anything get away. And then, you know, the leaders are kind of left. So let's get the playing field level and see what happens.
Great point. Mr. Jepson, yeah.
Yeah, thank you, Mary. I mean, I think on exactly as Martina was saying, FCPA was effective because the books and records part of that were much more onerous than can you find the actual bribery taking place. So what I always found interesting, and sort of the work of some of my teams was thinking about stock exchanges and complaints you could make to them. To the US, I think Sarbanes-Oxley is a really interesting opportunity because Sarbanes-Oxley requires those companies to have financial risk management processes in place. And going back to the beginning is that this issue fundamentally is about cost and cash management. It's about how power is used to take away payment to workers, whether they are through lack of wages or whether they're through penalties and other punitive measures. And so that speaks directly to books and records, to financial management. The other thing, and say, for instance, in the US is 10Ks, what is being disclosed in the 10Ks? How close is that to what people know that's going on the ground in those particular companies? Obviously, it's more relevant to companies that are looking at group structures and subsidiaries than third-party supply chains. But still, these things are important. The final bit, I think, is about actual corporate disclosure. Now, the SEC has just put out some more thoughts on, for instance, climate change. Now, what's interesting about those is that they are still focused on investor protection. So the focus is not on protecting employees and not violating human rights. It's about how investors are to be protected in relation to activities that the company may engage in. But again, it's a disclosure-based regime. For those who've ever written corporate disclosure, it's a game for lawyers and it's a game for consultants, and it's a compromised document. And it's also, a lot of it's standardized on what is everybody else doing. And so you have a situation where we're looking at the corporate disclosure with its greenwashing and its greenwishing and the consultants that have written by it. What amused us from Liberty Shared's perspective is that we were on the ground speaking to workers. We would look at the corporate disclosure, and there was a huge asymmetry between the corporate disclosure and what was happening on the ground. Now, those of you who will follow our sort of work on palm oil will know that we did make a complaint to the stock exchange in Malaysia. And that, I understand, was one thing that really brought ire. One was a WRO, and then in the very same day in the afternoon, we made the complaint to the stock exchange. And the complaint was quite simple, was there is a WRO. So somebody, this US law enforcement agency, this agency in the US has come to this conclusion, and yet the disclosure in the last sustainability document says something different. How do we bring these two things together? Or is this just corporate cognitive dissonance and we just live with it? And that was all we really asked. And, in the end, there's no requirement to do anything about it. There's no requirement to bring these things together. We know who wrote that sustainability disclosure. They were paid for by, by the company. But it was an example for us to see, well, what would the stock exchange do? What people do they have in the exchange that have the talent to read the documents, to understand what that disclosure means? And that was very important, is that the same question is asked of all stock exchanges. They now have sustainability disclosures. Who's in there that has the talent to read it, and what resources they have to, in some way, confirm that it's correct? And this is undeveloped. It's very nascent. And we don't see enough lawyers, and we don't see enough corporate lawyers and management executives trained to think about what sustainability disclosure looks like, whether it's got any veracity to it, and how they build systems to check that it's correct. It's a process of disclosure and language and drafting. It's not something that's fed back into the system. And again, that's why accountability has to happen, because this needs to be improved systemically rather than just piecemeal.
Thank you. Did you something else to add, or you're just ready? You're on the button, ready to go? Okay. I'm going to combine a couple of questions here. We've heard a lot of discussion about accountability. I think, Mr. Jepson, you started us on that. And then we've also sort of talked about the reality of the comments, and then what happens in court, et cetera. And we've got a number of questions about education, educating the consumer, educating businesses, et cetera. So I'd like to ask the panel where you see education in this question, and you can pick your audience, because I'm going to guess Ms. Vandenberg, she's in courts all the time. And we've seen a number of times, maybe some decent legislation has passed, the TVPA has broad ideas, but then judges read it a little bit differently. And we've talked about investor education, consumer education. So I wonder if each of you could just comment on what do you see the role of education in this question, and to whom? What audience do you think either needs to be educated, or with whom you have the most experience? That was a very Justice Breyer, long 20-minute question.
If I can just start briefly, when I was in law school, if you wanted to be a human rights lawyer, it was all about the Alien Tort Statute. Paul Hoffman was my hero, and I wanted to grow up and be Paul Hoffman. And Philartica, all of those cases that finally brought human rights into US federal courts, those were so important. And what we have watched over the last 30 years is the slow death of the Alien Tort Statute by 1,000 cuts. And so it lived on after Nestle. It's not gone entirely. But we need a new generation of human rights lawyers. We need the new sort of ATS true believers who are now the TVPRA true believers, the Trafficking Victims Protection Reauthorization Act, because I have to say that is the one law at this point that actually has explicit extraterritorial jurisdiction. That is the one law that we can use to bring foreign crimes into US courts. And then the other piece is, I was hiring for someone to do our trade work, and I couldn't find anyone. And no one, I think, with the exception of just a few people, ever thought of trade law and human rights in the same sentence. But the cutting edge of human rights work, the Paul Hoffmans of the future, are going to be trade lawyers in addition to litigators, because that is where so much of the cutting edge work is going on. So I've talked about this with law professors, the need to sort of bring up the next generation, because that is, I think, what's missing. I think we all have a duty to sort of mentor the next generation of lawyers.
Thank you. David, do you have something to add?
The education question is really important because so many of the things we're talking about have a deeply rooted urgency, right? Whether it's workers that are working in a plant that is unsafe, whether it's children, some of whom are at the border in Mexico, and not being able to get any sense of justice. So I think there are different areas, and for us as an Interfaith Center on Corporate Responsibility, I feel like we have a huge responsibility to educate and listen to a whole range of investors who haven't incorporated human rights criteria in their investment decisions. So more and more, we're sending, there are two things. One, educating the ICCR member institutions by not only getting the representative that often at ICCR is more on the social justice side and human rights side, but get the COOs of the organizations who are less likely to be in the education, they're more likely to need the education as to why this is important for their, not only their long-term investments, but the implications of investing in areas that actually hurt people and communities. So we're doing quite a bit there, and gathering the sort of chief investment officers of the organizations, and then secondly, reaching out to some of the the larger institutions, BlackRock, who has now adopted a human rights policy. So it's not just about environment. It's going to take a long time, I think, but already they're starting to vote with ICCR members on shareholder resolutions. And if they do, it brings up the vote from maybe the 30s to 80s or 90s, because often there are three, Fidelity is another, State Street is another, et cetera, Vanguard. If they vote their proxies, it really enables a decision, it sends a signal that is beyond sort of maybe the faith-based organizations that are there that may not be the largest holders, but we've organized to the point where I think the education has to come first and then continue, because the situation changes. And I do feel like, it's on the one hand, the sense of urgency sometimes, at least for me, makes me want to move really quickly because there's literal suffering. But to have a plan that really does thorough education. And we've seen it where really good education of workers, often by workers, has made a difference at the ground level. I do feel like education is a form of informed action.
Thank you. Lester?
So I think education is fundamentally important in all sorts of areas. So I'll pick just the one that's important to me, and that's in business schools and business management. When I went to my MBA, everyone was, it was in the early 90s. Globalization was all the rage. Theodore Levitt at Harvard had written his paper and was like, way offshoring, here we go. And that was it. And we offshored the hell out of it from the UK. I grew up in steel town of Sheffield, and there was no steel. And I grew up then I spent the rest of my youth in the textile towns of north of West Yorkshire and Bradford and Leeds. And there was no textiles because we'd sent it all to Far East, which is fine. I was half Chinese, so I benefited from that element, I suppose, in some way. When you look at MBAs now in business schools, they still don't address how does the shareholder maximization, value maximization, how does that intersect with human rights, with the environment, with other responsibilities we might have to the environment that we're working in. And that, I think, is where there is a massive failure at the moment. It simply is not enough information. And I've tested this out. I do go speak at MBA. I did a couple actually recently and sat and asked the MBA students what they'd heard about this. The answer was nothing. And it was not even on the course. And so we need to get serious about structuring education for business people, future managers, corporate lawyers, exactly as Martina says. and as David says, investors, thinking about how these things intersect. And, that intersectionality, unfortunately, some people treat it as a dirty word, but it's fundamentally important. We can just call it convergence then, for the sake of argument.
Excellent. Excellent. Well, we've heard an awful lot in the previous hour, accountability, transparency, respecting the worker, and these are important concepts. And I think you can see why. I'm going to give us one positive statistic to follow up on Martina's statistics. In this year's federal trafficking report from the Trafficking Institute, the numbers for labor trafficking were tiny, 5% of the federal prosecutions, if that at all. But in the civil suits, a majority of them were done by private lawyers, civil suits, in order to get some labor trafficking accountability. And I think you can see why. Please join me in thanking our panel.